listener production.
Hi, it's Tara Cassidy with you, and welcome to the afternoon edition of The Briefing. Coming up in our deep dive, deposed Venezuelan leader Nicolás Maduro and his wife have faced a New York court pleading not guilty to all charges, with Maduro's lawyers expected to argue his arrest was illegal and he's immune from prosecution. We'll unpack why and whether the case could set a precedent for the prosecution of foreign leaders. But first, let's check the afternoon headlines. It's Tuesday, the 6th of January. Senior Labor figures expect Prime Minister Anthony Albanese to back down on his opposition to a royal commission into the Bondi Beach terror attack. According to the Sydney Morning Herald, sources close to the Prime Minister say he's privately acknowledged growing pressure and is reconsidering his preference for a faster inquiry led by former ASIO boss Dennis Richardson. A group of Labor MPs has been lobbying behind the scenes, arguing only a federal royal commission would provide the legal protections needed for security agencies to fully disclose what went wrong. Insiders say momentum is shifting towards holding one, but no final decision has been made. Millions of Australians living on the outskirts of major cities could face bushfire risks similar to the deadly 2025 Los Angeles fires, according to a new report. Analysis by the Climate Council and Emergency Leaders for Climate Action warns nearly 7 million Australians in suburbs bordering bush or grassland are exposed, with up to 90% of homes built before modern bushfire standards. Cities including Sydney, Melbourne, Perth and Adelaide share the same dangerous conditions seen in Los Angeles, including heavy fuel loads, extreme heat and strong winds. With severe fire danger forecast in parts of the south this week, the report calls for urgent upgrades to homes, stronger emergency services and faster action on climate change. And exciting news for Lego lovers. The Danish company has unveiled its most innovative brick in 50 years. The smart brick looks like a standard Lego piece, but with a tiny computer installed inside, allowing it to become interactive with lights and sounds when touched. Lego says it's also bringing out interactive tags and minifigures, with its first Star Wars-themed smart toys launching in March. Now it's time to get into our deep dive on the first US court appearance of ousted Venezuelan authoritarian leader Nicolás Maduro and First Lady Cilia Flores after their capture and arrest by US forces on Saturday. The pair have pled not guilty to various narco-terrorism, drugs and weapons-related charges in a New York court in what's set to be a long legal battle, delving into not just these criminal charges, but whether the US breached international law in Maduro's arrest and whether he can legally be tried in the United States. Here to help us unpack this today is Juan Zahir, a Colombian-born legal scholar from the University of the Sunshine Coast. Juan, I imagine you'd be keeping a close eye on this case. What else happened when Maduro and his wife fronted court?
Yes, Maduro declared from the defendant's table that he's innocent. He said, I'm innocent, I'm not guilty, I am a decent man, I'm still president of my country. So his wife showed visible injuries from the capture operation, including bruising, suggesting possible rib fracture. So it was a little bit dramatic, this session. The defense attorney signaled that they would challenge both Maduro's head of state immunity claims and the legality of the military abduction. And the next hearing is scheduled for March the 17th of 2026.
And I heard he'd also made comments like he's claiming he's a prisoner of war. He'd said he's a decent man, the president of the country. And that comes to why they're saying that he supposedly can't be prosecuted. They're claiming that he's sovereign head of state and therefore he can't be tried in the US like this. What do you make of that?
Yeah, Maduro's immunity claim has substantial grounding in customary international law, which grants serving heads of state absolute immunity from foreign courts for all acts during their term in office. However, this will almost certainly fail in U.S. courts because U.S. jurisprudence defers to the executive branch the determination of who qualifies as a legitimate head of state. And the critical precedent here is the case in 1989 and 1992, Manuel Antonio Noriega. He was the leader of Panama. In that case, federal courts ruled that being a de facto ruler is insufficient for immunity if the U.S. government refuses recognition. So the State Department doesn't recognize Maduro as legitimate president following the disputed 2024 elections. So U.S. courts will likely deny his immunity defense.
And there are a number of jurisdictions, like you said, including the US, that do not recognize his leadership as being legitimate. How important of a component do you think that's going to play in this legal battle?
Yes, I think it's important first, as I mentioned, because the U.S. doesn't recognize him as a head of state, and therefore his head of state immunity wouldn't play. That would be under domestic U.S. law. And this is based in those two cases, as I mentioned before. One is the United States versus Noriega, which established the U.S. courts can prosecute foreign leaders for crimes with extraterritorial effects on the United States. And the other one is the United States versus Alvarez Machain, where the Supreme Court ruled that even forcible abduction from foreign territory doesn't defeat jurisdiction. So in terms of the legal system, sometimes for them, it's irrelevant how that particular person is before their courts. But this is different in the international system. In the International Criminal Court, for example, that was established by the Rome Statute, they have explicit authority to prosecute heads of state, but only for international crimes. And those international crimes are genocide, crimes against humanity, war crimes, and aggression. And Article 27 states officially that the official capacity shall in no case accept a person for criminal responsibility. However, the International Criminal Court can only prosecute crimes committed on territory of states that ratify the Roma Statute or by the nationals, and or unless the United Nations Security Council refers a situation. But here, the profound irony here is that the U.S. is prosecuting a foreign head of state in its domestic courts for drug trafficking, which is not an international crime under the Rome Statute, while refusing to recognize the ICC jurisdiction over itself. The U.S. doesn't recognize the Rome Statute. So ICC prosecutors, when properly authorized, they carry international legitimacy through their multilateral treaty framework, whereas unilateral domestic prosecutions after military capture operations like this one lack the legitimacy, even if the U.S. law technically permits them.
Yeah, and that contradiction has been pointed out by a few people, politicians and experts that are saying, well, they're saying follow the law in this instance, but not necessarily when it comes to the US. And people are alleging that they've also broken the law with this arrest. From an international law perspective, why is this moment so controversial?
Yes, it's absolutely right. This moment is profoundly controversial because it represents one of the most brazen violations of the post-World War II order. So international order's foundational principle is the prohibition of using force against another state's territorial integrity. Article 2 of the UN Charter is the cornerstone that emerged from the two world wars and states that members must refrain from the threat or use of force against the territorial integrity or political independence of any state. And as I mentioned before, sometimes the US in general doesn't like to sign treaties that would limit their own power and authority. But they ratify the UN Charter, and when they ratify the UN Charter, that particular treaty is a source of international law. Automatically, that treaty is part of the US domestic legislation. So when the US breaks the UN Charter, it's breaking their own legislation. So it's not about only international law, it's domestic law. Under their constitution, if they sign a treaty, they ratify the treaty, that's part of domestic legislation. So here, the question is how the different powers, different branches of government of the US could deal with this situation.
And do we expect the UN to actually take action against the US?
The problem is with the US is a permanent member of the UN Security Council, and they have the power to veto any actions, any resolutions, and probably they were not going to support anything against themselves. And therefore, it's unlikely that this is going to prosper at all. And also the attacks or whatever they did, it was that authorization obviously needed to be before the attack. But in terms of condemnation, there would be the United Nations Security Council is not really effective, and it won't be effective because, as I said, the U.S. is a permanent member, and they will be to any resolutions in that direction.
How seriously does international law treat violations of states' sovereignty in cases like this?
So, international law treats sovereignty violations with utmost gravity, because sovereignty is the foundational principle of the entire legal system. And the concept of sovereign equality, that all states possess equal legal status and territorial integrity that cannot be violated by force. And that was reinforced after the World War II, as I mentioned before, through the UN Charter. So the prohibition on violating sovereignty through military force is they call jus cogens. So it's a peremptory norm from which no derogation is permitted. And that is placed alongside prohibitions on genocide, slavery, and torture, for example. So the International Court of Justice has repeatedly emphasized this prohibition is absolute in nature, ruling that even minor sovereignty violations constitute breaches of international law. However, here we have this profound gap between how seriously international law treats sovereignty violations in theory and how effectively it enforces them in practice, particularly when violators are powerful states. Like in this case, the UN Security Council is supposed to enforce these rules. But when permanent members themselves violate sovereignty, like in this case, as the US now done in Venezuela, as we know, the system breaks down because those states can be to any condemnation resolution. As I mentioned before, while international law formally treats sovereignty violations as among the gravest offenses, powerful states often face no meaningful consequences beyond diplomatic condemnation. And to finish here, it is important to acknowledge that so many commentators are talking about the fundamental crisis of international law. And there is a long discussion about if international law is really law. Because if it's not enforceable, why we could call this normative system that if someone breaks that particular rule, but there's no consequences, why are we still calling this international law?
What precedent could this set if powerful countries can unilaterally arrest foreign leaders?
Yeah, this precedent is extraordinarily dangerous. This is threatening the fundamentally international relations system by legitimizing a return to power politics where might makes right. It's about power. If powerful states can unilaterally determine which foreign leaders are illegitimate or criminal and launch military operations to seize them, we've essentially abolished sovereignty immunity and opened the door to endless interventions.
And this intervention has been dubbed, like you said, illegal by many counterparts and the UN. But what would the lawful pathway to holding Maduro accountable have looked like?
So the lawful pathway requires working through multilateral institutions rather than unilateral military action. Of course, this type of statement could receive many criticism because they would say, yeah, but they have been trying that for many years. But what is the answer? The answer is just to break international law. So I think first the International Criminal Court could provide the proper venue for prosecuting heads of the state for serious international crimes. The second one would be maybe the US could have pursued proper extradition procedures, multilateral sanctions coordinated with the European Union, Canada, other Latin American countries, maybe also regional pressure via regional integration institutions such as the Organization of American States, etc. Of course, the solution is not there, and that's why it's a very difficult question. But the answer is not just to break international law and one of the most important principles, which is sovereignty.
Juan, thanks so much for sharing your insight and for joining me on the afternoon edition of The Briefing.
Thank you very much.
That was constitutional law expert Juan Cáceres, and that's it for this episode of the afternoon edition of The Briefing. We'll be back in your feed tomorrow morning with a deep dive on how to fix your sleep in 2026, and we'd love for you to follow us on Instagram and TikTok at The Briefing Podcast. I'm Tara Cassidy. Thanks for listening.